With this session update, I'm Shannon Lurkey. The Senate took up the remaining omnibus budget bill for this legislative session, the Health and Human Services Reform Finance Package. Here are some highlights.
This amendment removes language from Senate File 2360 on page 97 that would require abortion facilities to be licensed and subject to fees and inspections. There are hundreds, in fact there's over 1,250 clinics across the state that are not licensed in this way by the Minnesota Department of Health. I question why we are singling out clinics that provide abortion services for special regulation. For example, my daughter just had LASIK. That clinic was not required to be licensed. Both daughters had their wisdom teeth removed recently, which required them to be put under and have stitches and follow-up care. Those clinics are also not regulated as this bill would provide. We know from extensive reporting that abortion care is very safe. We know that less than 0.5% of abortions require follow-up care. We know that half of abortions are medication abortions and require no follow-up.
This puts abortion facilities licensed nearly identically to the licensing for birth centers. The primary difference is for abortion facilities, you don't have to have the names of the providers published, where at birth centers, you have to have the names of the providers published. The language is nearly identical. So when we're told over and over again, this doesn't happen anywhere else, literally look at the birth center statute. You can read it word for word. It matches up. We are saying health and safety matters. We are not going to have a Dr. Gosnell facility in the state of Minnesota. It doesn't provide an excessive burden because we use accrediting of abortion facilities that is already recognized nationwide. If the facility is accredited, then all they have to do is apply for the license. This is common sense safety for women undergoing a medical procedure. And while it might only be 1% that needs follow-up care, every 2 years, we get a report. The number of women who were hospitalized, the number of women who lost 500 cc's of blood or 1,000 cc's of blood, the number of women who had to have surgery following up because they had an intervention that was harmful to them.
2 lives go into this particular kind of clinic. 2 lives. The same life if there were a car accident and the mother were pregnant and the baby lost its life. There would be cause for action because of the loss of the baby's life. That's current Minnesota law. So first of all, let's realize that licensing a clinic and making sure that if this procedure is going to be done, we do want to take care and make sure that the mother is cared for in that regard in the best way we can. And licensing is one of the ways that we can do that, recognizing that it is not 100%.
As I understand it, there are more than 1,250 clinics across the state of Minnesota that provide a wide variety of care, primary care, dental care, eye care. Those clinics are not licensed. Creating a licensure scheme for one kind of clinic that does one procedure would be a vast departure from the way in which we regulate healthcare clinics in the state of Minnesota. And for those who are worried about the safety and well-being of those in their care, it would be the provider who is licensed. That would be the point of recourse if something untoward happened. And as Senator Johnson Stewart said, abortion is safe in the majority of cases, but if something untoward happened, the licensed provider would be the point of recourse, as is the case in other clinics across the state of Minnesota. The reason why this is referred to as TRAP is because it is targeted regulation for a certain type of provider. And that is why we should not include this in the law in the state of Minnesota, and we should rely on the licensure schemes that are already in place that are protecting Minnesotans in the delivery of health care across the state.
A very uncomfortable discussion because we shouldn't be discussing women's personal, private health with the government. I truly believe that this issue has been settled law at the federal level with the U.S. Supreme Court in 1973 with Roe versus Wade, which outlines, and I'll just remind people for the record, that there was a finding at that level, which is the supreme law of the country. The court divided the pregnancy period into 3 trimesters. During the first trimester, the decision to terminate the pregnancy was solely at the discretion of the woman. Government shouldn't intervene. At the first trimester, after the first trimester, the state could regulate procedures, and then during the second trimester, the state could regulate but not outlaw abortions in the interest of the mother's health. And after the second trimester, a fetus becomes viable, and the state could regulate or outlaw abortions in the interest of the potential life except when necessary to preserve the life or health of the mother. Members, this issue is settled law. We continually talk about it, and it's certainly something that it's of people of various beliefs and faiths have different opinions and beliefs of when life starts, whether it's a conception or viability. In this case, this is a matter of law. It's been something that has been argued at our federal courts, at the Supreme Court level. Members, having licensure for abortion procedures is, as Senator Benson mentioned, that she thought it was a reasonable step, that there is no undue burden, and it's common sense safety. My argument back is that it's unconstitutional to put undue burden on women to access health care, reproductive care, as this bill seems to do. Members, this is a very delicate issue. We do not want to become another outlier.
Life is precious, and it's a miracle when this all comes together and you actually have a baby. The process is amazing. I will say that I find it odd that we're comparing going to the dentist to going to have an abortion. But I will say that when you go to the dentist, it's very, very rare that someone dies. But I will guarantee you, every time there is an abortion performed, always someone dies. So there's a 100% death rate, at least in part of that equation.
This is not about how precious life is. We know that. We can agree on that. I pushed those 2 babies out. I was there. So I think I have the higher ground here. By the way, I'm also a Christian, and my faith brought me to this body. Today we are not talking about that. We are talking about the reasonableness of imposing government regulation on a special kind of facility. That's what we're talking about here with this amendment. So yes, we can agree, life is precious, it's beautiful. I loved every minute of being pregnant, twice. I wouldn't say I loved every minute of breastfeeding, but I did enjoy it enough to do it for 4 years. Okay, everybody can be uncomfortable for a few minutes. But the reality is, this is not about the preciousness of life. It is about putting an undue burden on those women who, because they are in charge of their own reproductive choices, and it is legal, as Senator Frenzen so eloquently told us, it is to take those burdens off the primary care providers that help them with their health care decisions.
I'm a business owner. I've been involved in dozens of projects, multiple different industries, and I can't think of one where I didn't have an inspection or licensure. Currently, I would say I have at least 6 licensing responsibilities every year for just 2 businesses. 6 for just 2 businesses. So I urge everybody a green vote on, a red vote on the A11 and in support of the existing language in the bill. And this is not uncommon for business. And the industries we're referring to, they are a business. And to have some oversight and licensure is not unreasonable.
Senator Johnson Stewart referred to these as special facilities, set apart. So they're going to be licensed differently than a place where you get a tooth pulled. Because, as she said, they are special. The Supreme Court is hearing cases this year on abortion. We're still in debate. And members, none of us on this floor should talk about how we have higher standing. We need to have a clear debate about the subject matter before us. So the language of this amendment, that this amendment is trying to remove, is about some common sense provisions about the health and safety of the clients, the patients at abortion clinics. It is straightforward, it is easy for Minnesotans to understand, and we should leave the language in and vote no.
There being 30 ayes and 36 nays, the motion has not prevailed. The amendment is not adopted.
To continue following these issues and more, watch legislative coverage Monday through Friday on the PBS Minnesota channel or visit our website, www.senate.mn/media.